My name is Michael Cohen. I'm Dallas Elder Law and Estate Planning talk. Let's start over again. My name is Michael Cohen. I'm a Dallas Elder Law and Estate Planning attorney. I'm joined by my co-host, Don Crawford Jr., who's been kind enough to be my co-host. We've been doing a radio show for years, and the radio show, well, it's over now. He sold his station, and here we are today, and we thought we'd continue the same type of format, but now with modern times, we
Thanks.
have an audio visual podcast. Well, today's topic is on Brian Wilson, the famous musician, Beach Boy. He was brilliant. He had the California sound, but life is not always a beach. And in his case, he had a mixed bag of planning. He had a large estate. He was married, and he had adopted several children later on in life. He had had some issues neurologically in later years. He had a trust, which was great. His trust was wonderful. He did a great job with his trust. It had the management of his assets. So there wasn't an issue there. His issue was that on his medical power of attorney, he had named his loving wife for many years as his agent to make medical decisions for him. That sounds nice and good, except for one thing. Life is not perfect. She died in 2024, the beginning of 2024. As we know, uh, Brian Wilson just died in June of this year, 2025. And the problem was that there was no alternate agent named. Well, they had children, even though he was probably close to 80, he had children who were still minors. And so they wanted to have the same people taking care of the kids at the homestead. He no longer could take care of things. It's kind of like he needed to have a conservatorship after his wife died to take care of him. He couldn't take care of his health, all of the different things that were necessities of life. So so they went to court, people went to court, and they was named a couple of trusted advisors to take care of him, one a little bit more on some of the assets, and the others really more just taking care of those medical decisions. So because of the fact that he didn't have an alternate agent, then that was the problem why they had to go to court for conservatorship. In Texas, we have guardianship of the person and guardianship of the estate. Guardianship of the person who takes care of you, guardianship of the estate who deals with your assets. Well, he had his assets taken care of because he had trust. So that was the great news. It's just that his medical power of attorney was deficient. On every document, you should try to have an alternate. The world is not perfect. I had met with somebody here just a minute ago, and she was widowed and she didn't have children, and she was struggling to figure out who's going to be her agent, who's going to be her alternate agent. And we said, well, we're going to have to think about this. And then we talk about different options. And in his case, he didn't do that. It could have been, when he did the documents, perhaps, I'm sure he had more capacity than when he toward the latter years of his life. And he may have then named maybe one of his older children, perhaps, if he felt comfortable with them, depending on the situation. Whoever it is, like in anything in life, you should always trust the individual that you choose as to whom you want it is. Who would make the decisions that you would make if you couldn't make it for yourself? And so there's several different documents that are end of life documents. Medical power of attorney is not necessarily an end of life document. It's who makes medical decisions if you're out of it. You could have had a stroke and maybe you'll regain capacity. Did we need to have surgery? Do we not need to have? Do we just have medications? But a lot of times it does deal with end of life. How's that different from a directive to physicians? A directive to physicians is what's commonly known as a living will. A living will is what I call the pull the plug instrument. If your doctor determines after talking with your family members, usually or whoever it is that you choose, that you trust to make the medical decisions. If you're going to either die within 6 months as determined by that doctor, or if you're in, let's say, a persistent vegetative state, you might live for longer than 6 months, but have no quality of life. Most 90 some odd percent of the people that we deal with want a quality, not a quantity of life. Let me die as gently as possible if I no longer have a quality of life. We see this. We're even seeing more. This is different than a physician-assisted suicide, although we're seeing more people do that too, unfortunately, or fortunately, I guess it depends on the way you look at it. We saw that in Britain, they just passed a law allowing that. And of course, there's a bunch of states here. We had a show on this. Remember, we talked about Vermont as the assisted suicide, physician-assisted suicide tourism capital. But really, this is not going to be something like that. This is only the end of life. If you're going to die, it's determined by the doctor. You might talk to this probably family member or whoever it is that you trust. Or if you're in a persistent vegetative state, do I believe in quality or quantity of life? I had a Marine who's a couple of weeks ago who said, no, I want to die hard. But most people just believe in quality, not quantity of life.
Sure.
Another document that we sometimes see is, sometimes we do, should be a basic document, is declaration of guardian in the event of incompetence or later need. It doesn't mean you have a guardian now, but there could be a dispute. Let's say that let's say you, Don, were not married, and then it's a decision between, it goes by next of kin. Well, mom and dad are your next of kin if you didn't have children. So is that who you would have wanted to make those decisions for you to take care of you and your assets? Or maybe would you rather have a sibling? I don't know. Is there going to be a dispute between the siblings? Oh, I want to take care of my brother and his money. So you could have a document, because a guardianship supersedes powers of attorney. You could have a simple document that says, I want so-and-so. I want Sarah. And if Sarah can't act, I want Bruce or whoever.
Sure.
And I don't want mom. Okay. All right. You could say whatever you want in there, and then the court's supposed to recognize that document. So that's a common thing. You may want to have an alternate on a HIPAA as well. A HIPAA is the ability to have access to medical records, even after death. You can have it say, powers of attorney terminate on death, but a HIPAA, you could be effective after death. HIPAA is the privacy laws. You know how you go to the doctor, you sign something every time you go to the doctor, who you could talk to. Yeah. Well, we make a universal HIPAA. It says, I don't care who the doctor or hospital is, you could talk to these people even after I die to find out what happened. So when the portal closes, they could still find out what's going on. Of course, all documents should have an alternate, whether you have a financial power of attorney who makes financial decisions for you if you cannot act generally, and who's an alternate. On a will, I just had today, I was looking at somebody's will, and they must have done it online. They named one person as the executor. Oh my goodness. I said, oh my goodness, what happens if something happened to you? Well, there's nobody left, nobody there. It says, it didn't even say what happens when somebody dies. It goes to my two children. That was it. It didn't say, and one of the children was disabled. Oh, they would lose their public benefits. Oh, it didn't give the power to sale. Well, anyway, there should always be an alternate. You should always say what happens if, just like if somebody died, you should say who's going to be the beneficiary if so-and-so predeceases you. Well, Brian Wilson's mistake was simply that he didn't name an alternate agent. He did a great job on the trust. He just didn't name an alternate agent. So the lesson to be learned is always have alternates.
I think so. And that's interesting because you got me thinking as usual, every program, every minute, basically. And is there a conflict of interest when the agent or the alternate is the heir, him or herself?
Not necessarily, because especially on any of these things, a lot of times there's an alternate. You could have a family member as whether it's be an agent or financial or medical power of attorney. In fact, most of the time it is.
Interesting.
But where there's a problem is like when you're in charge of somebody else that might cause a dispute. If it was, let's say, a sibling, and you're the trustee of the trust for the sibling, they're going to say, "What did you do with? Why are you giving me my money?" But in any event, as far as can they act, will there be if they're the executor? Well, a lot of times you have to say, "Oh, do we pay them? And if
Right.
so, what? And is
Right.
that fair?" Or is it reasonable, or do we say a certain dollar amount? Well, yeah, no,
Right.
you could be an agent and an executor, and it's okay if you're where there's a problem where healthcare providers, for example, if you're on a medical power of attorney, you shouldn't be if you stand to benefit as a medical. Let's say you had some nurse at the hospital, then they a lot of times say you can't even be witnesses if you're on a medical power of attorney, if
Uh,
you're working at, let's say, some sort of healthcare facility there when the
I see.
person signed the documents.
I see. It's complicated too, in the sense that what if the agent or the alternate is someone who makes $10 an hour versus an attorney who makes $1,000 an hour? Then what do you do? I think that's complicated also.
Well, that gets into I mean, usually on these type of things, you name people that you know and trust that would make the decisions you would make. It's usually not the attorney, it's usually a family member. Although in sometimes, like on the lady that I just met with just a minute ago, before this podcast, um, she didn't have any family, so we were going to name a bank. She had several $1 million, so we said, okay, maybe we ought to have a financial institution in charge of your money. And so there, um, banks usually don't die or become disabled. However, we were going to have the ability to remove whoever that trustee would be, which we'll get into in a future podcast with the story of Jimmy Buffett.
Yeah.
So yes, usually there is an alternate named, and maybe a way to replace an alternate sometimes.
And I've learned from you and others that it's not just important to name the alternate, but also name, as you mentioned 5 minutes ago, who you don't want to be an agent or the alternate. That's critical. It's not just who you want, but who you don't want.
That's
But
right.
it just gets more complicated. And I say this every show, but it does, every program. And this is why you need to attend Michael's next workshop, which is scheduled for Saturday, August 16th, I believe it is, at 10 o'clock. It's in person. It's free and it's very educational. Michael?
Yeah, it's at our office conference center at our building, which is just north of Forest Lane near
Right,
Central Expressway, south of
right.
LBJ. It's free, like you say, it's 2 hours. We ask people what they want to know, and then I write it on a board, and I either answer the question immediately, or we have a small presentation on the basic questions that people want to know about estate planning. And then, but we often will either weave it in, or I'll just answer the question and we just kind of go from there. We've been doing these for 13 years, and it just got to be a popular thing. And so we continue to do that. If you want to attend that free estate planning essentials or elder law workshop, all you have to do is call 214-720-0102. That's 214-720-0102, or sign up online at dallaselderlawyer.com. Dallaselderlawyer.com, and it is on August 16th at 10 o'clock.
Dallas Elder Law Attorney Michael Cohen. I thank you, sir.
Thank you.